Welcome everyone to our webinar today on recognizing, avoiding, and mitigating organizational conflicts of interest. My name is Leila Salim and I'm with FedMine. I'm happy to be joined today by Maria Panichelli of Obermayer. Next slide, please. A few housekeeping items before we begin. We'll have our introductions, a little bit about FedMine, and then our presentation by Maria. Feel free to use the Q&A to ask questions, and the slides and recording will be sent out to all registered guests later today. Next slide, please. FedMine was founded in 2004. It is a business intelligence platform that analyzes and simplifies the increasingly complex federal business landscape all in real time. We provide our clients the visibility that they need into their addressable market of business opportunities. As of very recent, FedMine is now a part of GovSpend, the largest provider of purchase orders within the state, local, and education industry. Next slide, please. We integrate from 17 sources, and it's all done by our back-end database technology. Some of FedMine's primary sources are FPDSNG, SAM.gov, and USA Spending for our subcontractor data. In FedMine, you'll often see the prime award connected to the sub at the task order level with the original solicitation attached. Next slide. While our main clientele are government contractors, both large and small, prime and sub, anyone who has a need for federal spending and opportunity data can use FedMine. This includes federal agencies, PTACs, and various other support organizations. Monitor federal spending, build a pipeline of recompete and newly forecasted solicitations, dissect your competition, quickly view agency profiles, and much more. I'm happy to present Maria from Obermayer, Rubman, Maxwell, and Hippel. She's partner and chair of the government contracting group there. And I'm going to hand it off to Maria to talk to us today about organizational conflicts of interest. Thank you, Maria.
Thank you so much. And thanks to everyone out there for joining us today. I know that it's a busy time of year with the federal fiscal year rollover being only a couple weeks prior and with all the new COVID stuff going on. So thanks for making time to attend today. I hope you find what we're going to talk about useful. Before we dive into the actual meat of the topic, I wanted to just tell you a little bit more about myself and my practice and why I'm here talking to you about organizational conflicts of interest. So as Leila said, my name is Maria Panichelli. I am a partner and the chair of the government contracting group at the law firm of Obermayer, Rubman, Maxwell, and Hippel, which is headquartered in Philadelphia. It's a full service law firm, so we do everything from family law, employment law, tax law, mergers and acquisitions, you name it. But my group in particular, the government contracting group, focuses exclusively on federal procurement. So that's what we do all day, every day. Our bread and butter is helping primes and subs on federal projects through every stage of the procurement process and everything that goes along with that in terms of legal needs. That includes things like REAs and claims and CDA claim litigation. It includes bid protests, both asserting and defending. It includes subcontract issues, including drafting and negotiation of subcontracts on federal jobs that are FAR compliant with the appropriate flow downs, dealing with subcontractor prime disputes on federal jobs, negotiating liquidating agreements, again, kind of you name it, we do it. The last part of our practice, or I should say the last two parts, the next to the last part is small business procurement. So eligibility analyses, teaming, joint ventures, mentor protege, small business size and status protests, both asserting and defending. And then the last piece, which is kind of what hooks into what we're doing today, is kind of a broad catch-all that we call performance and compliance counseling. And that kind of runs the gamut from FAR compliance to supplemental agency regulation compliance to False Claims Act compliance to Service Contract Act and Davis-Bacon Act compliance. Kind of any issue that comes up while you're performing or while you're preparing to perform. that's when you give us a call and we help walk you through it. So hopefully it doesn't get to the dispute stage, and hopefully, everything can work out well. So as part of that, one of the things we help with is identifying and, helping mitigate potential organizational conflicts of interest. And that's what we're going to be talking about today. So, a lot of people don't really know why it's important to even talk about organizational conflicts of interest, or otherwise known as OCIs. The reason is that OCIs can have a serious negative impact on you as a contractor. If it's determined that an OCI exists, it can lead to the exclusion of the contractor from the competition for a new job, the rejection of the bid or the proposal or the quote, as the case may be. It can lead to a termination of an existing contract if there's an OCI arising out of that contract. And in extreme circumstances, I won't say that this is common, but in extreme circumstances, it can even lead to suspension and debarment. So for all those reasons, those are all pretty negative consequences that I'm sure none of you want to experience. So it's really important that contractors understand what OCIs are, understand how to identify them, know how to avoid actual or apparent conflicts of interest. And they need to be able to do all of those things if they want to succeed in the government contracting, federal procurement space. So let's start with, how do we identify OCIs and what they are? Um, Under the FAR, which is the Federal Acquisition Regulation, for those of you who have been doing federal contracting for a while, that's kind of the Bible of government contracting. Organizational conflict of interest, shortened as OCI, means that because of other activities or relationship with other persons, a person or an entity is unable or potentially unable to one or more of the following things: render impartial assistance to the government, or the person's objectivity in performing the contract work is or might otherwise be impaired, or the person has an unfair competitive advantage. In other words, an OCI occurs when a contractor's performance on one contract with the government may compromise its ability to perform on another government contract, or may compromise its ability to compete for a government contract in a fair way. Now, in order to kind of put this in context, you need to understand that one of the main goals of the federal procurement system is fair competition, right? Things like CICA, the Competition in Contracting Act. The idea is that you always want to have a level playing field, and you always want to be giving, everybody the same shot, the same information, the same solicitation, so that everyone can put their best foot forward, and you're not stacking the deck against certain people, and you're not trying to maneuver certain people into an award at the expense of other people. So the idea behind OCIs is, we don't want any situation arising where one contractor has a competitive advantage over another. And what are the different ways that that can happen? Or what are the different ways that, what they're offering the government could be kind of interrelated or all intertwined or bound up with stuff they're doing on another contract? And what would the effect of that be, both with regard to the government and with regard to the other potential proposal, offers or bidders or what have you? Because then that's not going to be full and fair and open competition. It's going to be a little bit skewed. Someone's going to have a competitive edge, and that's not what the procurement system is about. The other thing to keep in mind is an OCI is distinct from an individual financial conflict of interest. So when you're talking about an OCI, that's one thing. There are other sections of the FAR that talk about, you can't, take contracting officers out to expensive ball games, and you're not supposed to be buying government officials lunch. Those are considered conflicts of interest, but they're not considered organizational conflicts of interest. So they're outside the scope of what we're going to be talking about today. But obviously, if you have questions about that, you can feel free to reach out to me or to your attorney to talk about what is and is not acceptable in terms of personal or individual conflicts. All right, so going into section 9.5 of the FAR, which talks more about OCIs. Why are OCIs so bad? From the government's point of view, OCIs are bad. Again, remember the idea that competition in contracting, open and full and fair competition, where everyone's on an even playing field, is kind of what the government views as the ultimate goal, or the starting point, I guess I should say, of the federal procurement process. So to the government's mind, OCIs are bad because, they can increase price, which is bad for the government. They can drive down value, which is bad for the government. They can stifle competition, which is bad for the government, but also bad for the various contractors out there that are trying to compete. It can result in unfair competition, undermine integrity of the procurement process, and the procurement systems in the US. Again, in the United States, unlike in some other countries, there's a really high premium put on, fair and open competition, and, no nepotism, no one person having a leg up, no unfair advantage. These are going to be themes you hear throughout today, but that's why OCIs are considered so bad. What the government wants to prevent is contractors being put in a position between choosing, on one hand, what's best for the contractor, or what will make the contractor's performance more lucrative or otherwise beneficial for the contractor, or make the contractor, able to get other contract awards. And then on the other hand, what's in the true best interest of the government. So the idea is, we're all human. While everyone would like to think that, when faced with a chance to be selfish or altruistic, or, selfish or act in the common good, that people would act in the common good. I guess, philosophy aside, the government comes down on the side of you can't trust people to always make those uninterested decisions. So you don't even want to put contractors in a place where they have to choose. You don't want to have them in a situation where on one hand they're choosing what's best for the government, and on the other hand they're choosing what's best for them, whether because it will make them more money, or get them more contracts that will make them more money, or get them reputational accolades, or anything that would boost their stock. So what OCIs are trying to avoid, or what the rules around OCIs are trying to avoid, is putting contractors in that position. The idea is, well, we'll just avoid having any situation where a contractor has to choose between what's better for them and what's better for the government, or what's better for them and what's better for the procurement system overall. So to that end, the government has put in place certain regulations, the purpose of which is to eliminate, or at least reduce to the greatest extent possible, organizational conflicts of interest. These rules are mostly contained in 9.5 or 9.500 and sequence of the FAR. 9.500, the scope of the subpart, kind of gives a general um, overview. It talks about the responsibilities, general rules, and procedures for identifying, evaluating, and resolving OCIs, and it provides examples to assist contracting officers in applying these rules and procedures to individual contracting situations. So the applicability, an organizational conflict of interest may result when factors create an actual or potential conflict of interest on an instant contract, or when the nature of the work to be performed on the an instant contract creates an actual or potential conflict of interest on a future acquisition. In the latter case, some restrictions on future activities may be required. So I've highlighted here the language actual or potential. This is an important concept to note when you're talking about OCIs, because the idea is, again, you're trying to avoid, or the government's trying to avoid, the regulations are trying to avoid, even putting a contractor in the position where they need to choose. So the idea is not, okay, now that the contractor's in that position, what do we do? The idea is you avoid it even further back. It needs to, you can't even have a whiff of a potential conflict down the road that in and of itself is an OCI that you want to try to avoid, and you need to start putting in place mitigation tactics, which we're going to talk about later, or you need to eliminate that contractor from competition, which is obviously not what the contractor would want. So the idea is, again, anytime that you've got a situation where the contractor is going to have to be choosing, that's a conflict of interest, and it can't be even a potential conflict of interest, or that's going to require some restrictions. FAR 9502 goes on to talk about kind of more specifics on applicability. It says that it applies, the OCI regulations that are in FAR subpart 9.5 apply to all contracts using government funds. So a very wide or broad applicability. They say that they're not limited, the regulations on OCIs, or limitations on when OCIs happen, are not limited to any particular type of acquisition. That being said, they do call out a couple different types and say they're more likely to occur in these types of contracts. So acquisition support services, advisory and assistance services, program management support services, technical evaluation services, systems engineering and technical assistance services. Those are all things that kind of fit in those four categories, or that are those four categories that they list in the regulation itself. The idea is that these kind of contracts that call for the contractor to provide advice and exercise subjective judgment, those are the types of things where bias and self-interest might come into play, right? So if that's what we're trying to avoid, we're trying to avoid putting contractors in a place where they have to choose between their best interest and the best interest of the government or the procurement system, or the another contractor overall. That's what we don't want. So that's going to come up more frequently in these types of contracts, where the contractor is providing advice, perhaps judging other contractors involved with the actual writing of the solicitation. And we're going to talk about examples in just a little bit, but those are the types that most commonly will see OCIs, where the nature of the contract basically sets up a contractor to be in that type of position where they need to make a choice. So there are three types of OCIs that are generally recognized: biased ground rules, impaired objectivity, and unequal access to information. So we're going to talk about each one of them separately. First, we're going to talk, though, about some general rules that are set forth in FAR 9505. What this generally says is that each individual contracting situation needs to be examined by its particular facts. So yes, we're setting forth rules, but these are highly specific, individualized factual situations that need to be analyzed as such. So what that does is it gives the government a little bit of wiggle room, a little bit of squish factor to analyze these situations. The regulations go on to say, within that squish factor, you should be exercising common sense, good judgment, and sound discretion, both, and these are kind of instructions to the government, to the contracting officer, both when deciding whether a significant potential conflict exists, and a potential OCI, and if it does, what is the appropriate remedy. So it says, look, we're going to set forward in these regulations, some things you need to think about, ways to identify OCIs, the reasons that they need to be avoided, and how to avoid them, and what you need to do. But we trust your discretion to a certain point. These aren't, this isn't a concrete list of exact things you need to do, or, an exhaustive list of every potential situation. You're going to have to evaluate each situation on its facts individually. You're going to have to come up with what's appropriate. You're going to have to give it some thought and use your good judgment and discretion, and just common sense. Kind of in line with that, the general rules set forth in FAR 9505-1 through 505-4 prescribe limitations on contracting as the means of avoiding, neutralizing, or mitigating OCIs that might exist. So they kind of give give the contracting officer some guidelines. Also, 9508 provides some illustrative examples. But those aren't exclusive lists. Conflicts can arise in situations not expressly covered in 9505 or the examples in 9508. Again, this goes back to the concept that the contracting officer should be using their discretion, using their common sense, and looking at things, on an individual basis. The rule also talks about, again, going back to the underlying principles here. The goals, or the reasons or the purposes of these rules are to prevent the existence of conflicting roles, where a contractor might be serving in two different roles simultaneously, and their work on one of those in one of those positions, or one of those roles, might impact or tempt them to be biased about the choice they make because it affects another role that they're playing. So existence of conflicting roles that might bias a contractor's judgment or put them in a position to make one of those decisions between themselves and the best interest of the procurement system. And again, going back to the idea kind of intertwined with that you don't want to have unfair competitive advantage. You want a full and open, fair competition, even playing field, nobody with a leg up. So the regulations say that in addition to the other situations that are described in the subpart, and by that I mean the examples in 9505-1 through 4 and the examples in 9508, generally an unfair competition exists, or I'm sorry, an unfair competitive advantage exists anytime a contractor competing for an award of any federal contract possesses information such as proprietary information that was obtained from the government or source selection information. So let's now talk about each one of those three, the three biggies of OCI. The first one is biased ground rules. So the idea here is that the OCI arises when a contractor, as part of its performance on one contract, remember they've got multiple roles and those roles could be in conflict. So this contractor's got one government contract and they've got a role that they're fulfilling under that government contract. And as part of that role, they've set the ground rules, or they've drafted the evaluation framework, or they came up with the evaluation criteria relating to the competition on another government contract, which means that they would have the potential, if they so exercised, but again, they don't have to have exercised it, just the potential that you're putting them in the situation to have this choice be, to be faced with this choice, choosing between their own best interest and the government. They could skew, if they chose to, intentionally or unintentionally, the competition in favor of themselves. So in other words, you've got a contractor who is involved as part of their government contract in setting up the way that another contract is going to be judged and awarded. Some examples of this are if a contractor drafts or advises on the statement of work or the contract specs for a future procurement, or if a contractor selects the evaluation criteria or sets the relative importance of the evaluation criteria for a future procurement, or if the contractor drafts or advises on the acquisition plans that can include things like the evaluation criteria, but also the budget, etc., for a future procurement. All of these things are examples that kind of fit into this category and could constitute a quote unquote biased ground rules end quote type of OCI. And again, the reason is that the contractor, if they're helping say, well, this is how we're going to judge contractors on, contract A over there. It's like, right, but you're part of contract B, which means you're controlling how contractors under contract A are going to be judged. So if you wanted to, what's to stop you from, building a solicitation that basically guarantees you're the winner? That's obviously not what we want. The primary concerns in this context are that by virtue of the contractor's current work, it has the opportunity or the ability to skew a future competition in favor of itself, even unintentionally, even if they don't intentionally make that choice to do stuff in their best interest. Sometimes it can be a little bit subconscious or a little bit unself-aware. The company in that case would have an unfair advantage in the future competition. That's not a fair and open playing field, and that's not consistent with the procurement goals of our federal procurement system. And they'd have that unfair advantage because the advanced knowledge and the power over the requirements or the solicitation evaluation framework for the future procurement. So that's biased ground rules. That's OCI situation number one. Number two is unequal access to information. This type of OCI arises when a contractor has access to information that's not public, whether it's proprietary or confidential or classified or what have you, and they have that access again through their role or as a contractor on another government contract. And the information that they have, the information that they know that isn't public information, could provide a competitive advantage in a later procurement. So non-public information for purposes of this includes stuff like proprietary information, non-public source selection information, etc. For there to be a quote unquote unequal access to information OCI, the information has to be real, substantial, completely useful, and non-public. The mere fact that a contractor is the incumbent, for those of you who have that question, is not going to itself create an OCI. In cases where non-public information is obtained from a former government employee, the issue will be treated as if the government had been obtained under a government contract. So in other words, if you are hiring people that used to, have other jobs where they have access to information, that could create a potential conflict of interest that you would have to mitigate or deal with down the road. Some examples of this: contractor has access to information about the procurement, which is not available to other contractors, like source selection information or other non-public information, such like government estimates or government schedules or desired attributes. And again, maybe that's because they're an ex-government employee that left the government and came into private practice. Or maybe it's because they were working, the contractor itself was working on another project where they got that information. Or the contractor has access to proprietary information belonging to one of their competitors, their pricing, or the way their proprietary or their unique technical approach that then they could copy. The primary concern with this type of OCI, the unequal access to information type of OCI, is that basically the contractor has inside information that it provides, that and having that information provides it with an unfair competitive advantage. And again, remember the idea, it's not that there has to be an actual conflict, there just needs to be a potential conflict. So to constitute an OCI in this scenario, it doesn't need to be shown that they've used the information. It just needs to be shown that they have it, or that they have access to it even. So it's a pretty low bar, which means that contractors really need to be aware of the actions of their or knowledge of their subcontractors or other team members as well, because that can create an OCI. This is especially true when the subcontractor or team member is a former government employee. Remember, if they have knowledge from that time, that's going to be considered them having access to certain, unequal access to information that could benefit them and your company. 3, impaired objectivity. So an impaired objectivity OCI is where a firm's ability to render impartial advice to the government could be undermined by the firm's competing interest. Again, returning to that theme, you have to choose in between what's best for your company and what's best for the government. And you're in a position where you're judging yourself, or you're rating yourself, or you're, evaluating yourself. And instead of being honest, you're obviously going to give yourself high marks, or, most people would be tempted to give themselves high marks rather than fairly evaluate. And that would, perhaps not be the best value to the government, would not be fair, would not be, good procurement tactics, would hurt the integrity of the procurement system. So this type of OCI occurs when the nature of a contractor's work under one government contract basically involves them, the contractor, using subjective judgment or giving advice, and its other business interests could be affected by the exercise of such judgment or provision of such advice. So the idea is, in that type of scenario, it would be hard for the company's objectivity not to be impaired. The nature of the work that it's doing on one contract would basically give it the opportunity, remember, put it in the position to make that choice, to benefit itself on other government contracts if it chose to be self-serving, or, to choose what's best for the government. And we don't even want contractors in that position having to choose between what's best for them and what's best for the government. So again, remember, a lot of this is about the potential or appearance or ability to do those things. It doesn't have to show that the contractor actually did it. So, for example, if the contractor were to have an opportunity to evaluate itself or an affiliate or a competitor, if you're going the other way, they could grade down a competitor, same way they could grade up themselves, either through assessment of performance under another contract or the evaluation of proposals, etc. This could constitute an impaired objectivity OCI. Again, remember, the issue is not whether the biased advice was actually given, but whether a reasonable person would find that the contractor's objectivity, could have been impaired, just that you're putting the contractor in the position to choose. Some relationships are going to be considered too remote to create an impaired objectivity OCI. Additionally, some tasks are considered too ministerial. But again, that's going to be one of those, fact by fact, good sense, good judgment, discretions, things that the CO needs to look at. So what are some examples of, this type of OCI? Example 1, contractor is in a position to test, evaluate, or assess the performance of its own product or services or those of an affiliate or competitor. Example 2, contractor is in a position to evaluate its own proposal or evaluate its own performance. Contractor is in a position, example 3, contractor is in a position to influence policy or regulations regarding services or products provided by the company. And again, the primary concern here is that the contractor has a financial interest in the outcome of its performance, and that its conflicting roles might influence its judgment and might not grade itself or its competitors fairly. This is the most important, or I'm sorry, most common type of OCI successfully challenged through the protest process. And that's probably because the facts are most readily available to competitors that can support this type of OCI. So this is one you will see come up in bid protests. You'll get bid protests from competitors saying, hey, they have an OCI. I don't think they've mitigated it. Therefore, they shouldn't get this contract, because then there would be an OCI. And that's something that, the regulations are designed to avoid. So the rules, and remember, we talked about some of the fact that 9.505-1 through -4 have some specific situations laid out. The general rules in 9.505-1 through 4 prescribe limitations on contracting, kind of as the means of either avoiding, neutralizing, or mitigating OCIs that might exist in other situations. But again, the idea, and I think I mentioned this a couple slides back, is that conflicts can arise in situations other than these that are expressly covered. So it's not only the examples that they give in 9501 to, 9505-1, 2, 3, and 4, or the examples in 9508, which we'll talk about in just a second. But these are kind of guidelines or examples, or, scenarios that should guide the contracting officer in determining, what they should do in terms of OCIs. Remember, again, it's going to be a case-by-case analysis. It's going to be for the contracting officer somewhere where they need to use their judgment, where they need to kind of talk about, or I'm sorry, use their subjective knowledge, their common sense, and do a independent individual evaluation on the face of the facts in every scenario. I'm not going to bore you with reading through the examples that are specifically set forth in the FAR. A lot of them are consistent with what we talked about before, the three categories. And you can kind of see what they're talking about. But the idea is that if you're providing systems engineering and technical direction, or if you're preparing specifications, or if you're providing evaluation services, or if you're obtaining access to proprietary information, you can see how those kind of marry up with one or more of the categories we just talked about. So these are kind of an example list, but not an extensive or exhaustive example list. And then, as I mentioned before, in addition to 9505, there are examples listed in 9508. And we will talk about a couple of those. So again, this goes on to say the examples are not the only situations in which OCIs can arise. They just illustrate certain situations in which questions of OCIs might arise. They're intended to help guide the CO apply the general rules. So, example A, Company A agrees to provide systems engineering and technical direction for the Navy on the power plant for a group of submarines. Company A should not be allowed to supply any power plant components. Company A can, however, supply the components of the submarine unrelated to the power plant. So the example here is that the system is the power plant, not the submarine, and the ban on supplying components is limited to those for the system only, because they would have, as the people involved, they would have some ability to kind of control the second procurement, and then that could result in an unfair competitive advantage. Example B, Company A is the systems engineering and technical direction contractor for System X. After some progress, but before completion, the system is canceled. So the government later says, all right, system Y is going to be the one, that we've developed, and that's going to achieve the same purpose as system X, but in a fundamentally different fashion. Now, Company A, remember, was the systems engineering and technical direction contractor for system X, but Company B is the systems engineering and technical direction contractor for system Y. Company A may supply system Y or its components because they don't have a conflict of interest because the system has changed. So you can see if, and again, I don't want to bore you with the legalese from the FAR and have your eyes glaze over. So we're not going to go through every one of these examples. But if you've got questions, if you're looking for, what the government is looking at, this is a good place to look and just kind of see some examples and see how they work in practice. But again, they all fall into those three main conceptual frameworks we talked about: impaired objectivity, unequal access to information, and impaired access to information. So when you're talking about the three different kind of things that you need to look for: bias ground rules, unequal access to information, and impaired objectivity, these examples are not separate and apart from that. They're kind of examples that fall into those three buckets. And you can see as you work your way through the examples, kind of which of the framework that we just talked about match up, and what the problem is. Or it's a good idea to kind of sit down with your people and see if you can identify the OCI. That's a good, or what type of OCI and why it's an OCI. That's a good exercise for those of you, in the company that are writing your proposals and are understanding the workload that you already have. That will help you identify what potential OCIs you have. So let's now talk about, okay, let's say the contracting officer is trying to evaluate if there is an OCI, is trying to do what they're meant to do under the regulations. As we've discussed, contracting agencies are responsible for determining whether an actual or apparent, remember, potential counts, conflict of interest exists. So the regulations in FAR 9.5 require the contracting officers to identify and evaluate potential OCIs as early as possible in the contracting process. They're required to try to identify, avoid, neutralize, and mitigate potential significant conflicts of interest. And again, the idea is that if you do that, you can eliminate unfair competitive advantage or the existing of conflicting roles that might put a contractor in the position to make a decision that could be biased or that might impair the contractor's objectivity. Although FAR subpart 9.5 is directed principally at the government, you will see in a second as we go through this that there is some responsibility that the contractors share as laid out in the regulation. So as a contractor, you need to take those responsibilities into account. And the idea, both because the regulations tell you to, but also because it's going to help you to mitigate and avoid, and hopefully then be able to still get an award, is to be really careful about identifying actual and potential OCIs, both proactively. So go through your own proposals, see if there's anything that the government could latch onto as a potential OCI. Go through your proposals with an eye towards what other projects you're working on and whether you are falling into any one of those three categories that we talked about, and what you could do to avoid it. And also, if the government reaches out to you about a potential OCI, then yes, obviously jump on that and be responsive and figure out how you're going to tell the government you're avoiding it, or mitigating it. But don't just be reactive, be proactive about it as well. Contractors, in addition to being proactive and responsive, should be actively communicating with the contracting officer to agree upon ways to avoid or mitigate OCIs. So the regulations kind of walk us through the process, and it tells the contracting officer generally that using the general rules and procedures in this subpart, so everything we've been talking about thus far, COs need to analyze planned acquisitions in order to identify and evaluate potential OCIs. They're supposed to do it as early as possible. And then if there are OCIs, they're supposed to find a way to avoid, neutralize, or mitigate them before contract award. Before issuing a solicitation for a contract that may involve a potential OCI, the CO is supposed to recommend to the head of the contracting agency, or I'm sorry, contracting activity, a course of action for resolving the conflict. And FAR 9.506 kind of lays out how they should do that. And we'll talk about that a little bit later. Regulation goes on to say that in fulfilling their responsibilities for identifying and resolving potential OCIs, COs should avoid creating unnecessary delays. So, act promptly. They should not create burdensome information requirements or excessive documentation, but they do need to document it, when a substantial or substantive issue concerning a potential OCI exists. So again, it's that idea that use your common sense, Mr. or Mrs. CO. Individual facts need to be analyzed, and you should be taking a look at the specific facts of this case. You should be asking the appropriate questions, but you shouldn't be going overboard or being overly burdensome. And you should be documenting it, but again, you don't need to create a whole tome of, of things, but it needs to be documented if you think there's an OCI. The contracting officer is supposed to award the contract to the apparent successful offerer unless a conflict of interest is determined to exist that cannot be avoided or mitigated. So, and this is from 9504E, I should say. So a couple different things to pull out of that first bullet point. This is where you can see how contractors could lose an award because of an OCI. If they're the apparent successful offer under the criteria set forth in the solicitation, but then a conflict of interest exists, that means they could potentially lose that award, right? But again, see the end of the sentence that says, a conflict of interest is determined to exist that cannot be avoided or mitigated. So that's where you get a second bite at the apple. If you could say, okay, I understand what you're saying. There is a potential OCI here. This is how we're going to avoid it. This is how we're going to mitigate it. And we're going to talk about, avoidance and mitigation in just a little bit. So you should give me the contract anyway. So again, that's kind of the context or the situation in which we're talking about how to deal with the OCIs. The government has identified there is one, or you, following my advice and being proactive, have identified that the government might think there's one. So now how do you make it clear that you're going to avoid or mitigate it such that you can still get the award and it doesn't cost you a contract opportunity? So the CO, back to the instructions to the CO, second bullet point, before determining to withhold the award based on a conflict of interest, they need to notify the contractor, provide the reasons that they think there's an OCI, and allow the contractor a reasonable opportunity to respond. So again, this is where you should be responsive and talk about how you're going to avoid or mitigate the OCI. And again, ideally, you would have analyzed this before the government even came to you, but maybe the government knows something you don't. So it's not apparent to you on the face of your proposal or, knowing what you know. But once the government comes to you and explains it, now you need to be responsive, show them how you can avoid or mitigate, show them that there is an OCI that can be kind of nullified, and then you can still be eligible for the award. If the CO finds that it's in the best interest of the United States to award the contract notwithstanding a conflict of interest, they can get a waiver. And then the waiver should be included in the contract file. In terms of that waiver, agency head or designee may waive any general rule or procedure of subpart 9.5 by determining that its application in a particular situation would not be in the government's interest. But any request for a waiver must be in writing, shall set forth the extent of the conflict, and requires approval by the agency head or designee. Agency heads shall not delegate waiver authority below the level of head of a contracting activity. So again, these happen, but they're rare. Most of the time, what you're going to be focused on as a contractor is, avoiding or mitigating, either prospectively or proactively, or if the government tells you there's a problem, then responding and avoiding or mitigating. So let's talk about avoiding and mitigating, and specifically mitigation of OCIs. Mitigation strategies, in other words, showing the government that, hey, we can get around this OCI. It's not going to cause a problem. It's not going to put us in that position where we're choosing, or we could have impaired objectivity or implicit bias. This is how we're going to set up safeguards to make sure that doesn't happen. That's mitigation. And it's going to depend on the type of OCI we're talking about. Remember, we talked about the three types of the three types of OCIs. The way in which you mitigate is going to kind of depend on which of those three buckets your situation falls into. Most of the time, or at least ideally, you're going to either be able to put restrictions on things, or you're going to be able to firewall between certain employees and other employees. And that's going to be, kind of the key way in which you deal with these things. Sometimes, though, it's unmitigatable. There's no way around it. And you kind of have to just be aware and recognize those situations in advance so that you don't spend your time and your money. So, two predominant principles to understand in accordance with FAR 9505 A and B, that there is a duty to the contractor or to the government. Again, remember, this is the idea that You don't want an unfair procurement system. You want there to be the best value to the government. You want the government to be getting the lowest price. You want full and open competition. And then along with full and open competition, you want fairness to contractors, everyone on the same level playing field. So the idea is that to the extent that what you're doing as a contractor could be biased, or you could be choosing in your own self-interest, you can put certain restrictions in place that's going to mitigate that type of OCI. To the extent that it's unfairness to contractors, the unequal playing field, the competitive advantage, a lot of times that's going to be avoidable or mitigatable by using firewalls or setting up certain protections where the people with the additional information or the people who are doing one thing aren't communicating with the others. And those are kind of the two major ways to think about how to mitigate. But let's talk about some tips on how to mitigate with regard to each of those three types of OCIs we talked about. So first, with impaired objectivity, again, remember that's where you've got a contractor kind of judging themselves or evaluating themselves or one of their competitors. This type of OCI can be mitigated by de-scoping an existing contract to exclude the performance that could be causing the problem. Maybe even removing a conflicted subcontractor. Sometimes you can mitigate this type of work by having the work performed by a firewalled subcontractor or by the government itself. It could be mitigated through increased government oversights, anything that kind of limits the contractor's ability to exercise that independent judgment that could be swayed by their personal interest. This is one of those ones where you really want to be proactive and identify this before the submission of your proposal, because then you can kind of build it into your proposal and into your proposal costs, how you're going to get around this potential OCI. Potential strategies are proposing to have the quote unquote conflicted work performed by a neutral. That could include the subcontractor, that could include certain firewall pieces of your own organization. That's not always going to be acceptable to the government. Sometimes exclusion is going to be the only acceptable option to the government. But again, if you can identify it, that's your first step. Knowing is half the battle, right? So identify it, address it in your proposal, address it as completely and as comprehensively as you can to avoid all of the the concerns on behalf of the government that we talked about. This could also require you in advance, if you're planning what contracts you're going after, to understand that there's always a possibility that the government says, no, this can't be mitigated. You might need to choose one contract or the other if you realize they're going to put you in a situation where there's an OCI, and you might need to bid, strategically. Maybe you want both jobs, but one of them is more lucrative, one of them is better for you, one of them is more reputational accolade producing. Maybe you don't take the little job that could potentially conflict you out of the big job. All right, what about unequal access to information? Again, this type of OCI is the idea that you've got, access to non-public, proprietary, confidential, classified, what have you information that could give you a competitive leg up. This type of OCI is usually going to be mitigated by establishing a firewall, kind of people who don't communicate, or a combination of security measures and procedures that kind of impede or block the flow of information between the personnel at your company who have this access and the other folks who are preparing your proposal. So if you've got two government employees that, have this information, they can't be involved and they can't be communicating, and you've got to put strict, kind of what are called firewalls, but obviously they're metaphorical, in between your people who are preparing the quote or the bid or the proposal and those folks that have the information. The potential competitive advantage resulting from equal access is nullified if the information can't be seen to cross that firewall. Another way to mitigate this is if the government's okay with giving the same information to all of the contractors. So in other words, yes, you know something, but now they all do too. So you all have the additional boost. This is another one where you want to identify it before the preparation of your proposal. At the submission point, it might be too late because then maybe you can't build a firewall anymore. Now, all the people that work on your proposals or the consultant you've hired to work on your proposals have the information, and you can't kind of, unring that bell. can't build a firewall after the levy has broken. And you obviously don't want to hire all new people just to write a new proposal and therefore mitigate. So a big one to identify early in the process. As I said, possible mitigation strategies: disclosure to all the competitors, non-disclosure, but with a strict internal firewall. And again, this all depends on the government buying off on your mitigation plan. They might say, nope, sorry, you've got a conflict and it's not mitigatable, so exclusion is the only remedy. So unfortunately, saving the worst for last in terms of mitigation, this type of OCI, biased ground rules, which again is one where you're kind of involved in setting the criteria or drafting the specs or selecting what evaluation criteria are going to be used, or the relative importance of those evaluation criteria on another procurement. This is very, very hard to mitigate, because once you have influenced the statement of work or the specs or the evaluation criteria or evaluation framework or the relative importance of the criteria, the harm's kind of already been done, right? It's hard to say, okay, well, we can mitigate that because you've drafted the whole framework by which the competition is judged. So a lot of times this is one of those ones that you need to be aware of far in advance. And I mean that when, you're sitting down and you're looking at your BD pipeline, business development pipeline, and you're saying, which contracts are we going to go after? This is one of those ones where you definitely want to say, look, we're not going to be able to mitigate a conflict between these two. So maybe we don't want to be involved in the smaller, less lucrative, shorter duration project where we help draft this solicitation. We want to be involved in the one where we compete for the project that the solicitation was drafted for. So we're not even going to go after that first one that can conflict us out. This is a big one where, you want to identify it before work on a procurement starts. It's really not that possible to avoid or mitigate after the work is performed. So you need to kind of decide in advance which contracts you're going to go after and which ones you're not. So overall, mitigation is not unilateral. And by that, I mean, you deciding that you've mitigated it and that it was, successful or sufficient is not enough. You've got to tell the government, you got to tell them what you're doing. You've got to have them approve it in accordance with FAR subpart 9.5. The timing is going to be a big part of that. You need to make sure that you are planning ahead. In most cases, it's not going to be possible to mitigate an OCI after the fact. So you have to address prospective OCIs. Definitely by the time the contracting officer tells you that there's a potential one, you've got to address it. They're required, the government contracting officers are required to reasonably consider any mitigation plan that you submit. But that doesn't mean they need to accept it. So, you need to make sure that you're working with them, the lines of communication are open, and that you're being smart about how you do this. In general, if there's a protest or if there's something like that, the GAO and the Court of Federal Claims will give substantial deference to an OCI mitigation plan if it can be shown that the contracting officer has thought about it thoroughly, has kind of vetted it, has really examined to make sure if the conflict is avoided. So again, this protests often arise out of OCIs. And, if you can show that you went through the proper steps with mitigation, if you can show that you built that into your proposal, you've got a much better chance of being able to maintain the award and avoid or at least win a protest. Again, just a real quick refresher on bid protests. There are pre-award bid protests alleging errors in the solicitation. Sometimes certain types of OCIs, especially the biased ground rules, can involve, a pre-award protest saying this is unfairly set up to benefit whoever. And then there's post-award protests, which can involve the other two types of OCIs. And those are general rules. There's obviously individual scenarios where things fall into different categories, but there are OCI situations that are protestable. And that is if the contracting officer doesn't bring it up, where you see a lot of these issues kind of being vetted out and litigated, and where you see a lot of the information about OCIs kind of out there in the government contracting world. So with that, we've got about 5 minutes left for questions. You can feel free to put your questions in the question and answer box, and I will do my best to answer them. If we have questions that we don't get to today, or if you would just prefer to answer your questions privately offline, or if you've got questions that come up at a later date or, in another area of the law, you can feel free to reach out to me. My contact information is on the screen. You've got my name, you've got my email and phone. You also have my social media channels, LinkedIn and Twitter, where I post when I'm doing things like this. When I post our blog articles that we write at the Obermayer GovCon Examiner blog, and where I share kind of news and developments that are going on in the federal procurement and small business procurement worlds. You've also here got link to our blog and a link to the webinar series that we ourselves at Obermayer are doing. There's a couple left on the 2021 schedule. So with that, I'm not seeing any open questions, but I will, I guess, then say thank you so much for joining us today. We're happy to have you, and I guess have a great day.
Thank you, Maria. As always, thank you everyone for joining us. We'll send out the recording and slides later on today. Bye-bye.